Hey everyone, and welcome to The Explainer. Today we are breaking down a fantastic local guide from Bouse Mediation on peacefully handling property line issues right here in Leawood. Now I want you to picture this for a second. It's a gorgeous, quiet Saturday morning in your Leawood neighborhood. The birds are chirping, the coffee is brewing, and then you casually look out your kitchen window, only to see a survey crew pounding wooden stakes right into what you always thought was your prized rose garden. Yeah. Suddenly, that perfect suburban peace is completely shattered by a simple tape measure. If you have ever experienced that sheer panic of wondering, wait a minute, is that actually on my land? Then this explainer is exactly what you need.
It's a seemingly simple question, isn't it? Where exactly does your property end? But man, the second a dispute flares up with the house next door, that invisible, imaginary line in the grass can suddenly become a massive source of stress and anxiety. It's actually wild how quickly perfectly rational, friendly adults can transform into medieval feudal lords defending their castles the absolute moment property lines are brought into question. I mean, we've all seen it or felt it, right? That sudden, passive-aggressive staring across the lawn when a new fence post goes up. Property boundary disputes are incredibly common, and honestly, they can escalate into an absolute nightmare almost overnight if you don't handle them correctly.
Okay, let's dive into this. We have a clear, organized roadmap to get us through the chaos today. We'll start with the property line problem, then look at court versus mediation, explain how mediation works, cover choosing the right mediator, and finally, preparing for success. Section 1. The property line problem. Common neighbor disputes.
You know, the sheer frustration homeowners feel when these issues pop up is entirely valid. What starts as a tiny disagreement over a few feet of grass can quickly turn into a massive legal fight that just ruins relationships and wrecks the peace of your own home. But the hidden problems that trigger these arguments, they're usually completely unintentional. First off, we're often dealing with encroachments. Think about a contractor accidentally pouring a driveway expansion just a foot over the line, or a really expensive privacy fence installed slightly off the mark. Then you've got conflicting surveys. This is where two highly paid professionals measure the land using different historical markers and somehow come up with two entirely different boundaries. Sometimes the culprit is an unclear deed description written decades ago that references something crazy like a large oak tree that was actually struck by lightning and removed back in the 1980s. And then there is the truly wild concept of adverse possession. Imagine your neighbor has been unknowingly mowing a 3-foot strip of your lawn and planting hydrangeas there for 15 solid years. Under certain conditions, the law says they might actually have a legal claim to own that land simply because they've been using it for so long. Crazy, right? These are the hidden sparks that light the fuse.
All right, Section 2, Court versus Mediation, choosing your path. And this brilliantly illustrates what to do when that fuse is lit. How do you put out the fire? Well, traditionally, people drag these boundary conflicts straight into a courtroom. But let's look at the stark contrast between that hostile litigation process and the collaborative, private approach of mediation. Litigation relies on a judge to make the final decision in a highly formal, incredibly adversarial process. Imagine taking your family's entire vacation fund, literally tens of thousands of dollars, and blowing it on attorney and expert witness fees just to fight over a garden border. To make matters worse, traditional court battles are agonizingly slow. We're talking years. Plus, every single detail is a matter of public record, meaning anyone can look up the ugly details of your neighborly spat. On the flip side, mediation is totally collaborative. You and your neighbor are the decision makers. It operates on a much faster timeline, often resolving the issue in just days or weeks, and it costs a tiny fraction of a lawsuit. Oh, and the best part? The entire process is completely private. You hash it out behind closed doors, and nobody else in the neighborhood ever has to know.
The biggest, absolutely most critical difference here is who actually controls the final result. In litigation, a judge, someone who has never lived in your neighborhood and doesn't know you at all, imposes a rigid ruling on you. You're just stuck with it. That adversarial process usually permanently destroys neighborly relationships. But even worse, a judge's ruling can create messy, complicated title troubles. Think about it. If you get slapped with a bad ruling that alters your property line, you now have a dark cloud over your property title. Good luck trying to sell your beautiful Leawood home down the road when you have to disclose an unresolved or court-mandated boundary defect to potential buyers. In mediation, though, you and your neighbor are collaborating to make the ultimate decision together. You hold the power to craft a creative solution that works for both of you, which protects your relationship and the future resale value of your home.
So moving on to Section 3, how mediation actually works, the process explained. Now, if you've never done it, the idea of formal mediation can sound a little intimidating. It kind of sounds like you're walking into a courtroom, but it's actually designed to be the exact opposite. Let's demystify what really happens in that room.
By definition, mediation is a structured, voluntary dispute resolution process guided by a neutral third party. But let's translate that. The mediator does not wear a black robe. They don't wield a gavel. They're not a judge, and they are definitely not there to declare who is right or wrong. Think of the mediator as a highly trained referee whose only goal is to systematically lower the emotional temperature in the room so you and your neighbor can actually hear each other clearly. They set up a safe, respectful space where the focus is entirely on finding a practical solution rather than just pointing fingers and assigning blame. There are basically 4 guiding principles that give this process its incredible power. First up is confidentiality. This is huge. Because everything is private, you can admit something like, hey, I might have messed up when I poured that concrete footing, knowing that this admission can never, ever be used against you in court later. That freedom encourages total honesty. Second is good faith. Both sides have to genuinely want to solve the problem, rather than just showing up to argue for the sake of arguing. Third is self-determination. This simply means absolutely no one will force an answer on you. If you don't like the proposed deal, you don't sign it. You retain complete control. And finally, impartiality. The mediator guarantees a perfectly fair, unbiased setting where neither side gets special treatment. Let's move to the actual steps and see how this builds. A typical session unfolds almost like a carefully guided story. It's highly structured and completely manageable. It kicks off with the mediator's introduction to clearly set the ground rules and ease the tension. Then, both parties get the floor to give their opening remarks, entirely without interruption. You finally get to just speak your piece. After that, there's a joint session to clarify the main sticking points. But what if things get heated? Because they do. If the tension spikes or negotiations stall out, the mediator can separate you into private rooms. These are known as caucuses. This is where shuttle diplomacy comes into play. The mediator will literally walk back and forth between the 2 rooms, privately negotiating a deal, keeping everyone calm, and slowly piecing together a resolution when tensions are just too high for everyone to sit at the same table. And if you're sitting there wondering if this is just a friendly, informal chat with no real teeth, let me reassure you, it absolutely is not. You get the absolute best of both worlds here. While the conversation might be flexible and collaborative, a signed mediation agreement at the end of the day is a legally binding contract that is fully enforceable in court. This means you don't just get a handshake that falls apart the very next week when your neighbor changes their mind. Nope, you walk away with profound peace of mind and the solid protection of the law. Section 4, choosing the right mediator. Finding the best fit in Leawood. Having the right guide for this journey makes all the difference in the world. You aren't just looking for anyone who printed off a basic certificate online. You want someone with formal mediation training from a rigorous program, backed by real-world experience specifically dealing with real estate and boundary disputes. Strong facilitation skills are an absolute must to keep heated emotions in check when talking about something as personal as a person's home. But crucially, you want local Leawood knowledge. I literally cannot overstate this. A generic, out-of-town mediator might completely misunderstand the city of Leawood's distinct property setbacks, specific homeowner association idiosyncrasies, and municipal codes. If they don't know the local laws, you could easily end up wasting hours crafting a beautiful agreement that ultimately violates local zoning standards and is entirely unworkable. Remember, you are the boss here. You are doing the hiring, so you should absolutely interview your potential mediator before bringing them on board. Ask them direct questions. What are your exact fees? What is your approach? For example, are they facilitative, meaning they just guide the dialogue, or are they evaluative, meaning they'll actually review your documents and tell you if your legal case is weak? What is their specific experience resolving property disputes in Leawood neighborhoods? You're bringing this professional into a highly sensitive, deeply personal situation, so you need to feel completely comfortable and truly trust their expertise.
Which brings us to Section 5. Preparing for success. Get ready to mediate.
Listen, walking into a mediation session entirely unprepared and blind is a guaranteed recipe for deadlock. You need to be fully equipped and ready with concrete facts to take the emotion right out of the room. First, gather your evidence. You want to keep the session grounded in reality, not some chaotic he said, she said argument. Bring your official property deed. Bring that blurry, folded-up PDF of the land survey from 1995, and bring a complete printed record of your correspondence. If there's a long chain of passive-aggressive text messages, angry emails, or certified letters between you and your neighbor regarding the dispute, print it all out and bring it to the table. Hard facts pave the way to clear solutions. Now, what's really interesting about this slide is this concept of BATNA. It is the absolute secret weapon of any successful negotiation. It stands for the best alternative to a negotiated agreement. Before you even sit down at that mediation table, you have to know exactly what your fallback plan is if the talks completely fail. Are you fully prepared to go to court? Are you prepared to just live with the fence right where it is? Knowing your BATNA provides incredible perspective. For example, your BATNA might be spending $15,000 on a lawyer and fighting in court for 2 agonizing years. Knowing that terrible alternative makes compromising on a tiny 6-inch garden border look much, much more appealing. Defining your BATNA and personal goals gives you immense confidence and clarity during the negotiation.
And when you are actually sitting at the table, the psychology of your communication style matters immensely. The very moment you point a finger and say, "You put the fence in the wrong spot," you instantly trigger your neighbor's fight or flight response. The wall goes up, the logical part of their brain completely shuts down, and they become purely defensive. Instead, practice saying, "I am worried about the fence." Simply switching from blaming you statements to problem-solving I statements acts as a surprisingly powerful de-escalation tool. It completely changes the energy in the room and invites genuine collaboration rather than combat.
We do need to take a solemn look at the reality of this process, though. Mediation requires 2 willing parties, and it absolutely has its limits. If the situation involves any form of harassment, physical threats, a massive power imbalance, or a neighbor who outright refuses to negotiate in good faith, mediation simply will not work. It is perfectly okay to walk away if the other side refuses to play fair. Knowing the limitations of mediation is just as important as knowing its benefits. In those specific, severe instances, the formal court system is there for a reason, and litigation might be your only route to protect your family and your property rights.
So the crucial point is this lingering question. Is the desire to definitively win a legal battle worth the permanent loss of your peace of mind and your neighborly relationship? Litigation destroys communities. It drains bank accounts, causes endless sleepless nights, and makes living in your own home absolutely miserable. Mediation offers a remarkably better way forward. It gives you the power to maintain control, save a tremendous amount of money, and find a creative, lasting solution where you can actually still smile and wave at the person living right next door. Thank you so much for joining me for this explainer. I really hope it gave you the tools and the confidence you need. See you next time.